Good morning to our viewers and our listeners, and I'm happy to be here. It's been a long time. I don't think that for us in government, there is any feeling or anything to talk about. I think we are moving on and everything is running perfectly. But it's important to also let viewers know from government's perspective that this removal was not political in any way. In fact, I happen to work at the presidency, and I can tell you that on assumption of power, if we had any preoccupation and major issues that we wanted to tackle, removal of Chief Justice was not one of the issues that government was concerned with. And so the point has to be made that this is not something that was on the agenda for President Mahama, for which reason someone can say that it is politically motivated. But it is also instructive to make the point that people cannot merely say that this was politically motivated without some form of evidence to show that there is a basis for making that statement. I've listened to, until today, he wasn't my very good friend, but now he's becoming my very good friend. My very good friend, Paul Adomotre. I've listened to Honorable John Darko, who happens to have a very big position, counsel to the entire minority caucus. Is that the case? Yes. And I want to put on record that contrary to the assertion of Paul Adomotre, this is not some philosophical difference between the judiciary and the executive. Contrary to Paul Adomotre's assertion again, it is not a matter where the Apex Court has delivered a number of decisions and government disagrees with, those decisions delivered. And so, pursuant to the disagreement, then some positive acts will be taken to remove the head of the judiciary. It is also not something which is orchestrated. And I want people to make time and listen to me. The petitioner, Daniel Ofori, is not a new person to the removed Chief Justice. The petitioner, Daniel Ofori, is an avid litigant. He's a businessman, by far one of the richest businessmen we have in Ghana. This man goes to court on a number of issues. He has issues with Madame Torkonoo, even as a high court judge. And Madame Torkonoo is no mean a legal practitioner, and for that matter, a judge who has practiced for over 22 years. And so it cannot be that the NDC came to power and within a space of 4 months, we had it on our agenda to remove the Chief Justice. Let me take you through a little bit of history. Maybe that history may not be known to my co-panelists, and so they may come to that conclusion. The checkered history is that Daniel Ofori had a case against EcoBank, and they had gone through the judicial processes, and Daniel Ofori had, won the case from the High Court through to the Supreme Court and even on review. And along the line, there were a number of applications which lawyers we do and we file. In 2 of those applications, suit number J8/114/2020 and suit number J7/13/2020, the Chief Justice then, as part of the panel, had ruled against Daniel Ofori. Among other things, Daniel Ofori then said that given the checkered history of this woman, and given some statements she had made in other cases against me, she had this likelihood to exhibit bias against me if I brought any case again in the matter of EcoBank. And so, Supreme Court, please ask your colleague to step aside The court granted this application that indeed Justice Gertrude Torkonoo was likely to be very biased against Mr. Daniel Ofori, and for that matter, she ought to step aside. That is very instructive because even as legal practitioners, we know that the test for asking a judge to step aside, especially when the person is a member of a panel and not a sole judge, is a very high or a tall thing that you need to mount. And so for the man to be successful, it should tell you the evidence that I believe was presented before the court. That was not even the case. And at the time, the court asked them
But it could have been that Torkonoo herself felt that there was no need in
No, it couldn't
this.
have been. Daniel Ofori took an application and the court granted that application. So she didn't recuse herself. It was the court that ordered that. But, you know, Salom, this wouldn't have been an issue because judges every time are asked to recuse themselves. I don't expect that if my friend is a judge and I have a matter, someone should not raise the issue. But this is what happened. After the court had asked Justice Gertrude Torkonoo to step aside, she then became a Chief Justice because at the time she was being asked to step aside, she was not a Chief Justice then. While she was a Chief Justice, there were 2 cases already pending in respect of the same matter that the court had asked her to step aside because there was a likelihood of bias. These courts were pending before first, the Commercial Court 7, and then General Jurisdiction 6. First, EcoBank had, issued a writ to set aside the judgment that Mr. Daniel Ofori had obtained. And then second, there was an execution process which Mr. Daniel Ofori commenced. While these 2 cases were pending, Justice Torkonoo then became a Chief Justice. You know the first thing she did? She transferred both cases from the judges without any cause. First, from General Jurisdiction 6 to General Jurisdiction 8.
She explained that the judge in question had some emergency or family matter that was going to take him out of the country for a long time.
Yes.
That was unknown to Daniel Ofori.
One of the reasons we have, and one of the challenges we even have as private legal practitioners, is the delay which is occasioned by our cases. There was nothing emergency about that.
No, so the judge applied that he had to leave the country. Of course, he didn't need to tell Daniel Ofori that.
Yes.
So as CJ, she granted it and transferred the case to other people.
In fact, she had the administrative right to transfer cases, which she exercised. And then she also transferred the Commercial Court 7-1 to, and in the Commercial Court 7 case, there was nothing that was wrong with the judge. Because I have appeared before the judge in Commercial Court 7 several times. She's such a good judge. There was no excuse of her going. So that's the second leg, which defeats the intention. But you see, even with that...
Her defense, sorry, Martin, her defense for that, or explanation was that once the 2 cases were related, the common practice is that you put the 2 together before the same judge. And that was
they were different. One was on execution, and one was actually on...
In respect of
EcoBank. So one was in the first one in Commercial General Jurisdiction 6. EcoBank was the plaintiff, and the one in Commercial Court 7, it was on execution. Those 2 cases were not so related. But assuming she even took the view that they were related, we ought to oblige her. That is her administrative right. I don't think she did anything wrong by exercising her administrative right. The optics may not have been good, especially because of the decision against her to recuse herself. But I don't think she did anything wrong, even with that. That is her right. But I am making this point to tell you that there is a checkered history between Daniel Ofori and the removed Chief Justice. Among other grounds, Daniel Ofori was aggrieved, and so a petition was brought against the Chief Justice. Nobody can tell me that by the account I have given, which I do not even want to debate the merits or otherwise, whether she did something wrong or right, but that was the genesis of the petition against her. So nobody can make a point that the petition for her removal was orchestrated, because some of these things date as far back as 2018, 2020, when the NDC did not even know that the removed Chief Justice has some ongoing friction with Mr. Daniel Ofori. So that point has to be made. I now come to the part about, and many people have made this argument, that although there may have been some misconduct occasioned, it shouldn't have been such that it would lead to the removal of the Chief Justice.
They were not grave enough.
I think that as a nation, we ought to agree on what we want. Do we want that wrongs should be done, and every time when wrongs are done, we find a scale and attach some weight to the wrong? Or as a nation, we are coming to a point where we are discussing whether wrong is wrong and right is right. Tell them, when a lawyer is defrauded, especially by false pretense, sometimes your probability of winning the case will be low. You know why? Because caveat emptor, we reasonably expect you that with the knowledge and requisite skill you have normally on legal due diligence, certain things should not happen to you. We apply the same standard to a Chief Justice. That as head of the judiciary, where your members or subordinates can misapply public funds, abuse office or powers of the office, you ought not to do that. The standard even is higher as a Chief Justice. And so let's not make the point and make it sound like, you know what, she may have misapplied the funds. She may have breached the laws on whether her spouse and child was entitled to the taxpayers' money. But let's ask, oh, it's just about $10,000 and $20,000. If we want to move away from that, so that I would be glad that we should be having and leading a jurisprudential argument where the offense of stealing will probably have, let's say, a cap, and say that where a person steals public funds below an amount of $20,000, that person ought not to be convicted, or that person ought not to be sanctioned. But where it is above $20,000, then the person ought to be sanctioned, because that is the invitation that is being made to the Ghanaian people.
So that's in respect of the per diem and the air ticket purchase.
Yes.
But she says that per her terms, conditions of service as CJ, she is entitled or was entitled to travel with one person, only one person of her choice, for 2 vacations in a year. And on both occasions, she decided to go with her spouse, and then on another occasion with their daughter. So if the conditions of service allow her to do so, where then will lie the wrongdoing? Okay,
so this is where will lie the wrongdoing. The Supreme Court decisions are not merely things that they say. The words and the decisions of the Supreme Court, Salom, are in themselves law. For which reason the Constitution says that where you disobey the orders or the decisions of the Supreme Court, it will amount to high crime. So a Supreme Court judge cannot feign knowledge or ignorance of the law. And let me demonstrate to you. As far back as 2015, in the case of Nobokor versus Attorney General, cited as 2015 to 2016 Supreme Court of Ghana Law Report 114, that's at page 114. The Supreme Court was confronted with a similar matter, or whether or not the emoluments of Article 71 holders were such that it could be varied by anybody. The Supreme Court came to the decision that the emoluments determined to be enjoyed by Article 71 holders could only be altered by the precedent. So this is very instructive, and I want people to pay attention to this part so that nobody will say that there was any witch hunting or there was any wrong done. So this has been the decision in the what we call the Nobokor case popularly. So everybody knows that when it comes to what the judiciary is entitled to, or what Article 71 holders are entitled to, in the case of Parliament, it is the executive that sets up a committee to decide. In the case of the executive, another Parliament then also decide what they should be entitled to. Now, having made this point on the precedent set by Nobuko, the Chief Justice herself, Salom, in the cases of Dafia Mekbo and 2 others versus Attorney General, and Kwame Bafoboni Abronye versus Attorney General, the Supreme Court, and here, let me say that the Chief Justice herself, she was the presiding judge. I mean, she was the chairman of the panel, and she gave the unanimous decision of the Supreme Court. And I want to crave your indulgence to read what she said. This is what she said. It's long, but I'll just make it short for
the Abronye case.
In the Abronye case, she said, the tight, precise listing of the identified officers shows that the framers of the Constitution intended to leave no doubt about the persons and entities covered, and the fact that the non-listed persons cannot be included or roped into the model of emolument setting by simple extrapolative reasoning. These are the very words of Justice Torkonoo. And then she proceeds to hold that the Act of Parliament approving the recommendations to directly pay the spouses of the President and the Vice President's salaries that were benchmarked to the salaries of ministers and members of Parliament as part of the emolument of the President and Vice President is an act that is violently, she even uses the adjective, violently inconsistent with the clear directions, intentions, and purposes of Article 71. It contravenes the spirit and the letter of the Constitution. The meaning of what I have just read is that the justice herself, Justice Torkonoo, said that when it comes to your benefits and entitlements at Article 71 holder, you cannot, by some exploitative reasoning, expand the scope. And so anybody who expands the scope to cover here the spouses of the President and Vice President violently violates the clear provisions, not just the provisions, but the intentions and the spirit of Article 71. How did she then come to the conclusion that she, by some exploitative reasoning, to quote her words, could violently, again to quote her words, I mean, expand the scope of her entitlement as an Article 71
even
holder,
though it was explicitly provided for in her conditions
I
of
didn't
service.
give this judgment. Tell them, I didn't give this judgment. I'm not a Supreme Court judge. She set the precedent. She laid down what the law should be. And the laws have been applied against her.
Very well.
What else will be my remedy? And Salom, let me respond.
And she made a point that even if that were the case, you know, the remedy was to surcharge her so she pays back.
No.
And we've seen that happen at the Public Accounts Committee, Auditor General's report, etc.
There would have been no need for an offense. Because every offense, whether the offense of killing, as long as I'm not killing, stealing, as long as no lives were lost, people could be given the opportunities to refund.
The element of intention is key. Unless, of course, we're able to establish that she intended to steal from the state in this manner.
Hello, unless somebody tells me the intent, that where the judge herself has set a parameter, that no Article 71 holder, you know, when we are ranking the heads of the arms of government, it is the President, and maybe sometimes the Vice President, not as head though, then the Speaker
and the Chief Justice.
The Chief Justice. Now you say that the two people who are part of an arm of government, the President, the Vice President, their spouses cannot be, I mean, Article 71 cannot extend to them. However, when it comes to my spouse, Article 71 can extend to me. But where I even violate the constitutional provision, I ought to be given remedy. How many people has she given the opportunity to remedy their wrongs? How many people?
But I of course, I need to move on. I need to come to
So I need to make the second point.
Okay.
I need to make the second point about Honorable John Darko saying that merely because the Chief Justice wrote to the President, it cannot be a ground for removal. I think that Honorable John Darko is a lawyer and cannot be forgiven if he makes that argument. A lay person can be forgiven, but he, as president or counsel to the entire minority caucus, is a very big post. He cannot be forgiven, and this is the reason. Article 1442 says that the other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State with the approval of Parliament. So it sets out the rule. But you know why it cannot just be a constitutional violation merely because the Chief Justice wrote to the President. This is why. The Chief Justice, on the 24th of June, 2024, at a meeting of the Judicial Council, made it expressly clear that indeed she was in communication with the executive. And it is based on that she wrote that letter to the President. I think she completely forgot herself. And these are the minutes of the Judicial Council meeting. Don't ask me where I got it.
You have me.
Yes. Because the principle is that.
That's very interesting.
Let's conclude from me.
I'll conclude and you respond. The principle is that, you know, as a lawyer, it matters not how you got it, even if you stole it. And this is the minutes. She further indicated that this is what the minutes captured, and I read verbatim.
No, but honestly, I don't think this should be allowed here because I mean we really don't know where this is coming from.
No, let's let's just say what
she said that she further indicated that she had received a letter from the President considering the request of additional judges to the Supreme Court bench. She indicated that she received a letter from the Honorable Attorney General and Minister of Justice dated 20th June 2024, recommending persons for appointment to the Supreme Court. And this is where it even gets better. The Honorable Chief Justice informed members that she had convened a meeting because she had received a communication that due to the political atmosphere, His Excellency the President, June 2024, the President was Nana Addo, was anxious to send the proposed names as well as the earlier nominations submitted by Council to Parliament. And this, we are being told that where the President, and you know, the President has nominated a number of Supreme Court judges. And so they did not want to add this new nomination. And so the agreement was that the request should come from the Chief Justice, but that is in violation of the law. Are we saying that?
I don't want to be the moderator, but I say this grounded in removal.
It was one of the grounds.